Good afternoon, everyone, and a very warm welcome to today's webinar session. We are privileged today to hear a panel of three legal luminaries discuss important legal themes mentioned in an enthralling publication titled All Rise, a judicial memoir by retired Deputy Chief Justice Dikgang Moseneke. The first of our panelists is none other than the author of the memoir, Justice Dikgang Moseneke, who I am delighted to welcome back to the School of Law. Justice Moseneke is an old friend of this university, having received an honorary doctorate from us in 2001, an honor bestowed on him by several other universities as well. Writing in the foreword to All Rise, a judicial memoir, former judge of the Constitutional Court, Justice Edwin Cameron, said this of his brother-in-law, Justice Moseneke, I quote, "In combination of intellect, personality, jurisprudential force, and physical presence, he was the golden heart of the court. Dikgang led the forces in the court who sought fair-minded development of the common law, generous-spirited application of constitutional principles, and unflinching insistence on constitutional observance by the legislature and the executive. Dikgang's pen exudes his life purpose to bring social justice, good governance, and enlightened conditions of autonomy to the people of our country." Close quotations. There can be no greater accolade for a judge, not just in South Africa, but also anywhere in the world. Detail Justice Moseneke's triumphs and tribulations as a judge of the Constitutional Court. It also provides a candid yet somber account of his personal disappointment when he was passed over repeatedly for the Chief Justiceship, despite being most eminently qualified to hold the position. All of this is expressed without an iota of rancor. The book also details the nature of the relationships Justice Moseneke shared with each of the Chief Justices during his tenure as Deputy Chief Justice. It is a measure of the man that, despite being overlooked repeatedly for appointment to the highest judicial office, Justice Moseneke continued to display the utmost fidelity to his country, to his judicial oath of office, and to each of the Chief Justices with whom he worked. Our second panelist, Ms. Andrea Gabriel, Senior Counsel, is an alumna of the School of Law, from where she graduated with her BA and LLB degrees in 1992. Soon after that, Andrea was awarded a Fulbright scholarship to Georgetown University in the USA, where she read towards a master's degree in law. On returning to South Africa, Andrea was appointed a researcher to then Justice, later Chief Justice Pius Langa at the reformed South African Constitutional Court. After working at the Constitutional Court, Andrea was awarded a further scholarship to read for an MPhil degree at the National Law School of India in Bangalore, where she wrote her dissertation on socio-economic justice. Andrea commenced practice at the Durban Bar in 1998. She was granted senior counsel status in 2010 and has served 3 terms as an acting judge in the KwaZulu-Natal High Court. Andrea has appeared in several important cases before the Constitutional Court and the Supreme Court of Appeal. Our third panelist, my dear colleague, Warren Friedman, is a senior and long-standing academic in the School of Law. Warren has held several academic leadership positions in the school, including a long stint of just under 1 year as acting dean. He teaches and writes in his areas of expertise and specialization, which are constitutional law, property law, and land use and planning law. Warren's other research interests include land reform, neighbor law, ownership, religious freedom, the separation of powers, and the structures of government. He has written and published extensively in these fields. Ladies and gentlemen, our discussions will begin with Justice Moseneke giving us an overview of his book. This will be followed by Warren's comments on specific aspects mentioned in the book that he would like to discuss further with Justice Moseneke. Warren may also pose a question or two to the Justice. Andrea will then follow Warren, where she'll give us her comments on certain themes in the book. and she too will be given the opportunity to pose some questions to Justice Moseneke. An important part of our session will be the questions that you, the audience, may wish to pose to Justice Moseneke. So please send your questions via the question and answer facility at the bottom of your screen, and I will present these to Justice Moseneke. Before I invite Justice Moseneke to speak, I would like to extend a very warm welcome again to all of you, especially those who've just joined us. And thank you very much. Over to you, Justice Moseneke.
It was already a good afternoon to you and indeed to the discussant for this afternoon. I also want to bring greetings to the university, starting with your Vice Chancellor and the law school, obviously, where my interest would be. Yes, I am an alumnus of the university, and I'm deeply proud of that. And it was certainly, I would have toyed or something if the law school had said no. They would not want to have anything to do with me. And I hope going forward, there might be an opportunity of an occasional lecture or something like that, just to reinforce my connectedness with the university. I happen to have a home not very far from where the university is, which I come to from time to time. So yes, that province is my second province of residence. Having said that, let me get on with what it is. All Rise came after a lot of deliberation. In fact, at the end of the manuscript, it was all done, written, and out there. And as usual, you wonder, maybe a little bit like a child you make or to bring to the earth and wonder what name to give it. But All Right popped up. It's not original. You're going to find all sorts of movies and things in the US in particular, which have the title All Rise. But for me, this is what it is. One, it's a normal call to duty that you find in every court, every morning, every afternoon. It's a call to do judicial business. Those are the words that you hear in every court just before judges, magistrates, prosecutors, and all those who are, and participants, indeed litigants, attention is drawn to what is just about to happen, and that is to do justice. And that is to restore equilibrium, because quite often disputes would disturb the stasis, something that the law tries to achieve all the time, a balance which then gets disrupted. And when the scale is so disrupted, then it falls on the courts. And for them, the cost to do that start with All Rise. That's the most superficial part of the meaning of the book. But All Rise is also a judicial memoir, and therefore it tells a journey, and my journey, and quite often as a fly on the wall, I saw just about all of that for 15 years. And judges have, particularly judges in South Africa, have been quite reluctant to disclose their stay on the bench. And I was saying at some discussion place the other day, it's a little like the passage right, where you go up the mountain and you're told never to say a word about what happens there. Or it's a little like living in a nunnery, if you will, cloistered. And nobody goes out to write a memoir out of a nunnery or out of a monastery, whether it's in Tibet or wherever else it might be. So the culture is the one of silence, of non-disclosure. And I thought this is an opportunity to break that culture, to lift the judicial gown, and to talk in ordinary language to citizens in their vastness about what the judicial function is. And I become a protagonist only to be able to tell the story. It's weaved around me But you go and read the book, you will know that it's actually also a history book. It walks painstakingly through the establishment of the Constitutional Court, the judiciary just before the transition. And I draw your attention to the fact that in 1994, 98% thereabouts of judges were white males. Not even white females made the cut. There were about 2 or 3 white female judges. And therefore, in that sense, apartheid always distributed this white male-centric power arrangements. And therefore, the challenge was, how do we ensure that the judiciary becomes much more integrated, much more representative, and capable of carrying the new mandate that comes out of our Constitution? And the debates around whether the judges sitting already should take a fresh oath, whether they should be kept or not. And I take you through those difficult discussions that we had in 1994 at the time. Mr. Mandela appoints Arthur Chaskelson and the court starts. And I take you through the history of how it happened and some of the memories about whether Nelson Mandela had appointed an appropriate bench given the transition. But actually he had, because history showed that they built a remarkable foundation stones for our jurisprudence that was to come. And remember that the obsession was to change society, to keep the door firmly closed on apartheid and its tentacles, and to allow only the good, as Ismail Muhammad CJ once wrote, keep the bad out, allow the good in, so that we can proceed in our path to try and recreate society and have a much better place to live in for all of us. So it was an important moment to set up that court. And I tell you about just the big figures that sat in the court. They don't come bigger than John Didcot, do they? Ismail Muhammad, Johan Krichler, Richard Goldstone, Pius Langer and other Chaskelson were both counsel. They'd never been judges before, but they were in the mix and in the leadership. So it was that kind of court. And then for the first time, we see academics, no less than 3 people drawn from the academy onto the court. And there was a break from a past that very arbitrarily concluded that law professors can never be good judges. And that, of course, history has shown that that was all nonsense. With Cato Reagan, with Yvonne Mokgoro, and Albie Sachs, all of 3 were professors of law. And then I carefully take the book from there and take you through the Mandela era and the honeymoon, and take you through the Mbeki era, when the first fallout with the judiciary was with the TAC case, where judges put their foot down, having done it, of course, earlier, like in Hugo versus the President of the Republic, when Nelson Mandela gave amnesty to women only, and some man called Hugo said, "What about me?" So it was still a golden era, if you like, depending on your take on whether 1994 was a genuine transition or not. And we can have that debate a little later. And then I take you through to past the Chaskelson court and the tension that developed between those inveterate adherents to the common law and common law only, and those who really thought that the Constitution was transformative and it ought to help rearrange and change our society for the better. And you see in the early judgments, and I take you to a judgment like Mhlungu, where Kentridge AJ at the time said, you reach the Constitution as a last resort. Otherwise, you must stick to the common law. And you know that I'm one of those guys who thought not the other way around. Sorry. All sorts of law now is a constitution. And all other laws must abide by the supremacy of the Constitution. And Arthur Chaskelson did us that favor when in pharmaceutical he said, there's only one law in this country. There's only one administrative law. not one drawn from the common law or another drawn from the Constitution. And therefore, there's one neighborhood, one jurisdiction, and ultimately, of course, the Constitution was amended to make it clear that the Constitutional Court is the highest court in the land, and also re-emphasizing the supremacy of our Constitution. And I carefully take you through the Langa Court and where I became Deputy Chief Justice, and the explosion as there was contestation of political power within the ruling elite, starting in Polokwane. Then you saw cases suddenly formulated in legalese, in legal terms, but most of them in essence were contestations for power. Most of them were an attempt to overreach for one reason or the other to enhance power. And then we have a relentless litigation, starting from Shabir Sheikh's case. And every one of them would run the gamut from the lowest court to the highest court in the country. And the courts were besieged, if you like, with litigations of that kind, which you can call lawfare, if you like. But it was 10 years of incredible, and I spent time very carefully to take you through that period. And that was the Langa Court with me and past Langa Elderham, and tremendous political storm swirling all the time around us, precisely because we're making decisions that not everybody liked. And I take you through the pillaring and the criticism and the suggestion that some people are spies, Johan Froneman and Johan van der Westhuizen and myself, and they added for good measure to Lima Donsel, I don't know who else, in order to try and discredit the judiciary at the time. And then we moved through the Ngobo era, brief as it was, but it was also quite contested. And that gets us into the Mogoeng era as Chief Justice. And there too, I'm at pains to say, yes, there was a lot of political litigation, sort of litigation with a political tint to it, sometimes overload to it. But in fact, the court did many other things. In fact, the bulk of the jurisprudence is not about cases around exercise of executive authority, or generally the exercise of public power, but actually about the concerns of people and the strides that were made in dealing with that. And I should have mentioned earlier that I take time to show you how hard a high court judge works, the workload, the demand for dedication, the early mornings, the late evenings. And I also take you through the magistracy, where easily 85% of all our people find justice or injustice at the magistrate's court. Never go any further than that. And therefore that we need to keep that institutional robustness if we are serious about the rule of law and institutions that accompany it. And the book peters out at the end of, as Justice Mogoeng gets appointed as Chief Justice, and I tell you what work we did. It was a lot of work, but also how important it was for me to make common cause with him. And the terms of the common cause were my standard mantra. It can't be what the ruling elite wants. It can't be what pleases the ruling party. It must be what the Constitution and other law demands of us, and what is good for our people. And that was a touchstone, which I hope will be the touchstone of any young lawyer, young prosecutor, young investigator, or public servant. That surely must be it. And then I end up with life as a Dimeni, just after my retirement. And to show you how low a point we had reached. And I thought that was my lowest point. And to end, of course, remind you that I had started with my visit to Morogoro, where the historic African National Congress conference was held, and where Solon Mahlangu Freedom School was built, and where other edifices were built, which spoke to the values that reigned at the time. And Life as Sedimeni was in sharp contrast because it was far removed from, if you like, liberation values and or values that are enshrined in both international law, in convention law as well as in domestic law. And that is really what I wrote out in Life as Sedimeni to demonstrate that point. That by and large is the book. It has, I hope, a number of light moments. It tells you how judges work, how judgments are written, and so on. And that is really the long and short of All Rise. It is dedicated to all young people in this country and on the African continent. And in the dedication, I do make the point that they deserve dignity, freedom, and social justice. And when these are absent, I pray and hope that they would know it and hopefully do something about it. Thank you.
Thank you very much, Justice Moseneke, for taking us through what I personally found to be a most fascinating account of your time primarily at the bench. May I now ask our first panelist to make some comments on All Rise and then possibly pose some questions to you on those aspects that he would like to get further discussion going on. So it's over to you now, Warren. Please go ahead and most welcome.
Thanks, Professor Reddy, and thank you especially for inviting me to participate in today's webinar. It's really an honor and a privilege, and I'm very much looking forward to it. So I want to start by congratulating Justice Moseneke for writing such an engaging and wonderful memoir. I was gripped by it from the first page to the last. And as I'm sure you know, Justice Moseneke, that unlike in other countries, for example, the US, we don't have a strong tradition of judicial memoirs in South Africa. And over the course of my academic career, I've had the opportunity to read a few other judicial memoirs, and I can confidently say that yours stands out head and shoulders above those. And I think it stands out not only because of its strong South African focus, but also because it's written in an accessible and eloquent and really at times a poetic style. It also tells, of course, a fascinating and important story about our constitutional project, and really, I think about us as a nation. So what I want to do in my opportunity now is just perhaps to mention a couple of points that I took away from the book, and then to pose a question to you. So I think that, that the book gives rise to many different, or it contains many different aspects, and it can be understood on many different levels. But for me particularly, I think there were three key levels, and I've roughly called them the personal, the institutional, and the national. And I want to say a few words about each. So to start, at the personal level, the book really recounts the story of your judicial career. First as a High Court judge, then as a Constitutional Court judge, and finally as our Deputy Chief Justice. And this aspect of the book alone, I think, gives rise to many interesting issues, hopefully some of which we'll touch on today. And I think you've mentioned one or two already. So for example, the process that's followed in a democratic South Africa for appointing judges. The experience you had of working with judges from the old order initially, the strict seniority, the criticisms about when a judgment could be reportable or not. I think the daily workload of a High Court judge, I think for readers who are unaware, that will really be eye-opening, how much a judge has to read. And you sit in court all day and then you go home at night and you read sometimes thousands of pages of a record. And then, of course, ultimately, the very personal question I think you pose for yourself, which is whether you were a good judge or not. So I think that's the first aspect that really stood out for me. The second aspect was really, I suppose you could say, the institutional level, where you recount the story of the Constitutional Court itself. And what I found particularly fascinating was the way in which you divided up the history of the Constitutional Court into three, I suppose we could say, eras. So first, the establishment of the court in 1994, and the focus, I would say, mostly on the division of power between the different spheres of government, especially between national and provincial. And then following that, the increased focus on the fundamental rights, the Bill of Rights, in interpreting and applying those rights. And then finally, of course, what has perhaps been the most difficult era for the court, the political issues, and really holding the executive and the legislature to account. So focusing on the issue of political accountability. I must say, what I also thoroughly enjoyed about that aspect of the book was your detailed explanation of the way in which the court's judgments are debated and drafted and carefully checked. I particularly loved the idea of a final collective read-through. And I'm very sorry we don't have something like that in academia. I'm sure it would stand us all in good stead. And then thirdly, at the national level, of course, the book, as I think you've just told us, recounts our journey as a constitutional democracy from 1994, when we perhaps naively thought that everything was possible, to where we are today, to a more realistic position we are today, where we've realized that the constitutional project is much more difficult and certainly much more contested than perhaps we ever thought it would be. But at the same time, that project is still full of promise. And I think that did come through in your wonderful chapter on the Esidimeni life arbitration, despite the horrors and the failure of government, I mean, the fact that the provincial government was prepared to apologize and admit its fault. And then, of course, the ruling you made about constitutional damages. But also, I think that perhaps this aspect of the book gives rise to the most difficult questions about our constitutional project. So, does the Constitution simply reflect Western liberal values, or does it reflect African values? Is it capable of achieving the transformational goals that it set for ourselves? And I think you mentioned one or two of those. But let me then turn to posing a question. So the question that I wanted to pose really relates to, I guess, what I called the second aspect, which is the story about the Constitutional Court as an institution. And as you point out in your book, the court has been subject to a lot of criticism, some of it fair, some of it unfair. So there's been criticism about its jurisprudence, about its caseload. And I see recently on Twitter some criticism about its website. I'm sorry to say that the website is not being updated as often as it should be. But despite these criticisms, I think that it's been a remarkably successful institution, perhaps even the most successful of all the post-apartheid institutions. Because not only did it survive the political onslaught during the Zuma era, but with some of which you so eloquently described, but it also asserted its authority, and I think pushed back strongly to hold the executive and the legislature accountable. And in doing so, it really enhanced its legitimacy. So for me, that's interesting, because it's interesting to compare the way our constitutional court has survived and thrived with the situation in many other countries that became democracies in the early 1990s, particularly, let's say, Poland and Hungary. So in both of those countries, the dominant ruling party has essentially stripped courts of their independence and severely undermined the rule of law. And although I suspect that might have happened in South Africa, it didn't. I mean, we can be very thankful for that, but it's fascinating for me to think about why. Why didn't the same thing happen in South Africa? Why did our constitutional court do so much better than constitutional courts in other new democracies? And in fact, so much better than many other post-apartheid institutions in South Africa. And of course, there can be many reasons. I mean, one that I find particularly interesting is proposed by Professor Tinus Roux. And to very, very crudely put it, I think one of his arguments is that it's partly because our judges were politically astute, they were politically aware. And because of their political astuteness, they were able to manage the relationship with the other branches of government in a way that not only ensured the survival of the court, but also ensured that it thrived and became the legitimate institution that it is. So I'd just be interested to hear your thoughts on that. Why did our constitutional court perform so well? Why does it enjoy such a fabulous reputation amongst the legal profession, the people, and I would say even the executive? And is it partly because we have politically astute or politically aware judges? Thank you.
Justice Moseneke, if you will take that question, could you please unmute yourself? Thank you.
Thanks, Professor Reddy. I will, and again, thank you to Professor Warren Friedman. The reward of an author is getting at least one person to read the book, and is the kind of joy that is difficult to describe. But when somebody has worked through your book, you find an enormous reward, and I'm grateful for that. Thank you for that. And yes, indeed, the book does run through personal, institutional, and national levels. And as one worked through it, it was quite difficult to know how to mishmash it and bring it all together. But somehow it hung together in the end. And you're quite right, there was a very, very conscious attempt to make it accessible. There's a hope that it will be read by certainly every law student, hopefully, and let alone the academy, and that it will be read by most citizens to understand this institution that worked in their midst. Yes, I hope there will be questions about whether or not our constitution is sufficiently African or a post-liberal document, and whether it is capable of actually redirecting our society to a safe place of freedom, social justice, and dignity, which were singularly absent in the colonial and apartheid arrangements. So that is an open question, and I hope we can debate it later. But thanks for your remarks in that regard. Is it fish or fowl, or both, or none? So I hope we'll have that. Yes, the court has come under criticism, particularly lately. Institutions, I've learned, like the flowers you grow at your home, like whatever you plant, you've got to till them all the time. Got to look after them. You have to give them all the things that will enhance their growth and their usefulness. And when I got to the court, I hope I succeed in the book, there was firstly, there was just a honeymoon determination to make things work. If you remember at the beginning, it is Nelson Mandela who got up to the podium and said, "Let freedom reign," if you remember. And I'm trying to use evocative language to remind you how he said, the sun should never set on so glorious an achievement. One of those lines, ringing lines, and he said, "Let there be salt, let there be water, let there be bread." That was Nelson Mandela ushering in what appeared to be a very great prospects of changing society. So from then on, the people looked after the institution. They built a new court. I wasn't there. I was the second wave. And they set up new systems. They, for instance, were very determined, as you know, in the book, "Stop calling us my lord and my lady, certainly not honorable. We just Justice Moseneke, or Justice Sex, or Justice Mokoro, whatever it is, or Chief Justice or Deputy Chief Justice. Describe us with the work we do, and not confer honor, which normally is earned and not just given on a platter." So they did a lot of things to try and change. They introduced all those things I described about how to write judgments, the mutual accountability. You owe every sentence to your colleagues who are going to sign up on your judgment. So if they're unhappy with the sentence, that's enough for you to reconsider or reformulate and so on. So it was that collegial hard work and determination to make the Constitution work. And I must say that the second thing was, and something that is not just peculiar to the Constitutional Court, the architecture of our judiciary is such that we acknowledge human fallibility, as I say in the book, and hope that the structure will serve as a sieve. So if you are 11, as you are in the Constitutional Court, there can only be room for a lot of excellence, mutual accountability, collegial accountability, and producing the goods. I talk a little about the judicial pen drying up, or intellectual constipation, as I say, and so on. So yes, it was, and anybody who's plugged there, and I know Advocate Andrea will be talking very shortly, it was quite a culture that sprung out. Added to all that, of course, it was a demand for accountability by everybody else. And we were the super referees, and we had to blow the whistle every time it was indicated and it was necessary. And I think that is where the trick sat. deeply conscious of our responsibility imposed by the Constitution and the people. And some of us, my standard mantra that got me into a lot of trouble was, it cannot be about the ruling elite. Not now, not anywhere else. Certainly not, not in Belarus, not in Hungary, not in Poland, not in any of those former East European democracies, almost all of them. I used to attend conferences of constitutional courts, and they almost all caved in for all sorts of reasons, and they remain unusable up to now. They're not helpful. So and lastly, South African people started loving the court, looking up to it. And we knew the expectations of the people was that we would do the right thing. And the fact that you could appoint just one person as a Chief Justice, you can't change the court. You've got to, in the executive, you can do that. She will have power over others, which is staggered. But in the judiciary, even in the High Court, you seat 3. You must persuade the other 2. Supreme Court of Appeal, you seat 5. Constitutional Court, you seat 11. So it's the force of your intellect and your arguments and their ethical, power that would actually get to those outcomes. So I hope that there'll be more work done at the court, and I hope that there'll be more concentration on its primary task, and not to lose the ball. And we must try and find the best amongst us. It must remain representative of our country, but we must find not who we like, but who we trust that they will do the job most conveniently. So you need both an integrated court, but also, which we have achieved. Just my last word there, Professor Friedman, is that the judiciary is more transformed than any other arm of the state currently. If you think that over 65% of magistrates and judges are people of color and women, where we started with 90%, 98% of white males. So we've had quite a journey, and need to look at your television and look at the spread of your magistrates, the spread of your judges. And so it is one of the examples of something that was good there. Not perfect, but something good has come out of it.
Thank you, Justice Moseneke. I know Warren has got another question, possibly, Warren, that you'd like to pose at this stage. You are muted at the moment, Warren.
Thanks, Moseneke. I always do that. Yes, so Justice Moseneke, I was interested to hear your remarks, obviously, about the Chief Justice, and that the Chief Justice is clearly just one amongst 11. So my second question really does relate to the office of the Chief Justice, because as we know, next year the President has to appoint a new Chief Justice, and I see that the debate around the criteria for a new Chief Justice has already begun, as well as, I think, the interesting question of whether we should have our first female Chief Justice. But I think also what's interesting to me about the appointment of the Chief Justice is, as you describe in your book, I mean, the work of all constitutional court judges is particularly heavy, but the Chief Justice even more so, the Chief Justice and the Deputy Chief Justice, because they're responsible for the administrative side of the court as well, not just the jurisprudence. And then, of course, the Chief Justice now heads up an entire Department of State, the Office of the Chief Justice, which I can only imagine how demanding that must be. So it makes me think about the criteria for the Chief Justice, both as the head of the court, but as the head of the Office of the Chief Justice. And I'd be interested to hear your thoughts on that, on whether that has changed, perhaps the criteria that must be taken into account, the fact that the Chief Justice now heads up this Department of State, and I suppose even perhaps more fundamentally, whether that arrangement is sound, whether it is in fact possible for one individual to carry both or fulfill both positions. Thank you.
Yes, thanks for the question. I'm going to try and keep it tight and short. You know, in other jurisdictions, actually you have the administrative head of the court. They don't call him Chief Justice, what they'll call Master of Rolls, for instance, in the English courts. They had a position like that. And in other jurisdictions in the US, you find administrative head of the court, who might also be a judge, but who would have those particular skills. I'm in deep doubt now. I know when it was introduced by Justice Nobo, who was quite big on administrative, on institutional independence, understood it intellectually, but I didn't know that it would be practical. So when I was not appointed Chief Justice, I was spared the burden of being the one who carries the, that administrative load. And that gave me room to write, my heart out by way of judgments and so on. And I did mainly that part of the court's administrative work. Mine was judicial and not administrative. I'm not convinced that one person should do that. You've seen in the book how hard judges work, including the Chief Justice, who must bring his hair weight along. And besides administration, the Chief Justice keeps the court together intellectually, shows the trend, where to go. It's 10 other people, and people like Arthur Chaskelson and Pars Lang and so on understood very well that you're better off with a court that have some cohesion. You don't want the American format where you split all the time. As we did at least once, very seminally, in that particular judgment that called Glenister. The court was split right almost in the middle, and with one swing vote. But our court has always been different because the leaders often had insight into what outcomes ought to be and would work hard to get all the other colleagues to get on board, or most of the colleagues to get on board. So you need merit must not be left behind. And if there is a woman of that stature and merit, I don't mean stature in the vague sense, I mean of those qualities, then so should be it. I don't think the court could only be women stop or men stop. I think there should be a fair evaluation of senior. In the book, I spent time, remember, to pay tribute to women judges and all those who have come up, and remind you that, for instance, people like Judge Masipa, who did the Pistorius trial, is one of the real early front runners. She was a senior judge, and she ran that trial admirably. I've heard in conferences all around the world. You may differ with her understanding of Dolus Eventualis, if you like, but actually she ran it very world-class, very masterly, so unintrusively and so on. So it may well be a woman. I have no particular objection to that. I just want to make sure that all those qualities are there. Why? We have to preserve the judiciary. We have to preserve the institution. It's a vital arm of state, together with other arms of state. If you weaken it and you break it, of course, there'll be more hardship than otherwise. That's the point. It's institutional robustness that we need. And if a lady Chief Justice can give that to us, so be it. If a man can't give it to us, they shouldn't become Chief Justice either.
Thank you very much for your response, Justice Moseneke. I noticed that our friend, Ms. Andrea Gabriel, is chomping at the bit. She wants the opportunity now to make her comments and pose a few questions to you. So welcome, Andrea, and please go ahead. Thank you very much.
Thank you. Thank you. Can you hear me? Thank you, Professor Reddy. Thank you.
Yes, we can hear you well, Andrea. We can hear you well.
Thank you for having me, and hello to everybody, and hello again, Justice Moseneke. I cannot tell you how relaxing it is to sit on this side of the table against you and not have to wait for you to lean forward, take a deep breath and ask me a question from that bench, because those were the worst days of my life. It's very good to have you, Justice Moseneke. Judge, to me, the beauty of your book is that this is exactly what I searched for when I started practice 22 years ago. In December 1998, I had just arrived back from the Constitutional Court and back from India, and I was looking for inspiration, and I was looking for something to read to prepare me for this life in the law. And you have written a book about a human being whose job was the law, a human being who was sentenced to imprisonment for 10 years at the tender age of 15. But you didn't end up as a victim. You use that as an opportunity. And it is precisely that kind of inspiration that I was looking for in the legal writing, in the books in this country, to guide me through my years, future years in the law. And I couldn't find it. And I'm so grateful to you. And I want to say a resounding thank you to you for having written All Rise. I believe that it is an incredible human story, an incredible human tale of the journey of a simple soul through the law and through the practice of law. And I think it's an invaluable contribution and an aid for law students and indeed for legal practitioners such as myself. So thank you from the bottom of my soul as a lawyer for this. I must say you've written with a great deal of humility, and something that I never quite realized about you is that you do have a sense of humor, which is recounting the tale of Senator Obama, as he then was, and you interrogating him in the judicial tea room about the sources of his surname. And as you write in the book, that you had to swallow your fine cheek when he told you exactly where he hailed from on the continent. So I must say, I chuckled out loud when I read about that. But moving on now to more serious things, I think you are quite right. This is an invaluable historical treatise for all of us, written in accessible English for lawyers, non-lawyers alike, for practitioners, for law students, for anybody with an interest in society. It's a valuable aid to help us go through the next few years. And it's important that you recount those early years. You know, you write about the words of Nelson Mandela when we entered our democratic project. And I was in the courtroom the day that the first court was opened and Nelson Mandela came to open the courtroom. And he stood up in court. And the very next day, as you will recall, we were hearing the death penalty case. And he stood up, this majestic, tall man. He took a deep breath and he said, the last time I was in a courtroom, I was waiting to hear whether I would receive the death penalty. And he welcomed us. And the day the judgment, the death penalty judgment was handed down, there was not a dry eye in that courtroom. And so to me, it's important that you capture those heady early days when we were filled with such promise, with such hope for this new legal order, which, you know, if I may quote from your book, which you say was the new design. The new design was that the Constitution was to become the supreme law, and no law or conduct may breach or dishonor it. Everyone, including the president and his government, the Speaker of Parliament, and the Chief Justice and his courts, was to be bound by the supreme law. All armed forces and security agents, all institutions of state and all public servants were to obey the command of the Constitution. And then, of course, that brings us very squarely to the real import of the title of your book, All Rise. And to me, it is a timely reminder that the hope in this country lies only in two institutions. This is my view, in the courts and in civil society. The question arising from having read that passage is, what the hell happened to us? What the hell went wrong. You know, I can express it no better than you have, Justice Moseneke, when you write in a section on the class of 95, and yet none of these setbacks can ever justify erasing the seminal moment of change that Mandela symbolized and stood for. He ushered in the space, however limited and imperfect, and we, the foot soldiers, failed him. We failed in great part to grasp the nettle. We lacked the courage to change our world irreversibly, and particularly of those in need. Instead, we gorged ourselves on our newly acquired power over the people. We fed ourselves sick. To me, that is the importance of All Rise coming at the time that it does. It is impossible, Justice Moseneke, to switch on the television, to open a newspaper, to watch a video on the YouTube channel without reading about the excesses of the executive and the legislature in this country. And as I interpret the book, All Rise, it is to say to each of us that the honeymoon days are over, that it is time to reclaim what is in danger of being pulled away irretrievably from us. It is time. We are a baby democracy. We're not even 25 years old. And yet during the greatest pandemic on earth, we have a minister who stands up and says, you will send your children back to school, but no, I can't guarantee their safety. Really? Is that the contempt in which the citizens of this country are held? And so, Justice Moseneke, my question to you is this. When you say all rise, what is it that we as civil society are meant to do? What is it that we as law students are meant to do? What is it that I, as a senior counsel, must do when the night before a huge, let's call it land claims trial, I am called by a legal advisor to a certain politician to say, no, no, counsel, you must ask for an adjournment. Because some legal advisor in government circles hasn't done their work. And so it's easier to ask for an adjournment at the expense of taxpayers' money than to actually sit down and do the work and get on with land redistribution in this country. So all rise, what do you propose to us, Justice Moseneke? Primarily as lawyers, secondly, as members of civil society. How do we rise against the contempt with which we are seen and with which we are treated? How is it possible, and I will stop now, how is it possible that the graves of the soldiers in Morogoro lie there unadorned, without an epitaph that you write about in the prologue of your book? And yet, in the space of one lifetime, your lifetime, mentally ill people are left to starve to death and to decompose in morgues that have no gas to cool down the decomposition of the bodies. Enough is enough. Tell us how to rise, Justice Moseneke. Thank you.
Thank you, Andrea. We'll now give Justice Moseneke an opportunity to respond to your question. Over to you, Justice.
Thank you, Professor Reddy. The person who spoke now is one of my favorite counsel. She trained at our court, the Constitutional Court, and came later to appear before me and other justices many times. So it's a very accomplished counsel, and you have heard from the elocution. But Andrea, thank you ever so much. And our friendship over the many years, I should disclose, because I don't think you are entirely impartial or dispassionate in your judgment. But thank you for your kind assessment. And again, I'm flattered that you found time to read as you pick up the details that one wrote about, sometimes with pain, sometimes with ecstasy. But yes, I'm not going to repeat any of the things you've said because you've said them so eloquently, so probingly. We all hurt, don't we? And I want to go to the instances you have set out, those instances. And the book is juxtaposed in that way, Morogoro on the one hand and Life as a Dimeni on the other, to show you the horrible journey we've gone through from the one end to the other. And the loss of innocence and loss of values in the process. And that is plain to see. I don't have to preach to anybody. And the book does not do that because that is plain. All people can see that for themselves. I think the first point I'd hoped to raise, the awakening I would foster, is civil accountability, active citizenry. My prayer and hope, as you know, is that people will know when it no longer works and that they would stand up and try to make sure that the bad doesn't persist and the good should more flourish. And, you know, I'm thinking of peaceful marches around the world, and there are many lately. Think about Thailand. The young people wake up and say, we don't want a king. We want no king, no monarchy here. And they fill up the streets peacefully and say, we'll not have a monarchy. Look at Belarus. We're unhappy with those elections, and we don't think that's an honest outcome. You know, in All Rise, I complain about my stay in Zimbabwe and the call I made in the infancy of my judgeship when I said, these elections are not free and fair. But I couldn't persuade politicians about that. And look at the price that the Zimbabwean people have paid after that. So electoral hygiene is something very important. But you look around and go and look at Venezuela lately. People in the streets, look at Nigeria. The reports are very disturbing this morning. There's 3 other countries on the African continent. Look at Mali. Look at Cote d'Ivoire. And so on. So there does come a time when people will understand that civil accountability is part of their duty. And sometimes it takes the form of organized civil society. I've been very proud, for instance, of the young people that came out of the Constitutional Court, some a little just after your time, Andrea, who have gone out to set up Section 27, who have gone out to set up equal education for all, equal education. And all they do is to go out and count everything that's to be counted that would add to the quality of the education that we give to our children. And they report on this ceaselessly. And they report on pits, toilet pits, and they report on all of those things that show, they report on water and its absence, the kind of water people have to live on and drink. In short, they report on our dishonoring right of access to water, right of access to food, right of access to health care, access to quality education, access to social grants, which often get stolen. Money for grants gets stolen, and so on and so on and so on. So, and the absence of institutions that will protect all of us and make us be in a better space. And all these are, of course, commanded by the Constitution. So the first point, I would hope that there'll be more citizens who would know and understand, and in a peaceful way will say, we're not taking this. We want to have an input in the way the budget is put together. We want higher accountability on how the money is used. We want higher levels of accounting tell us where did the land reform get stuck? The first laws we passed in 1994 was the restitution of land rights. 1995 was one of the first statutes that we passed. That's how strongly people felt about pursuit of land justice. You know the backlog. I have a published paper with statistics that shows you just how we have not got down to the business of doing that. And when I sat in the court, I looked and looked and looked and waited for expropriation cases. Dololo, none. Just as there were no cases on prosecution of misuse of public funds. I had no such case in 15 years as a judge. So there's a slippery slope of absence of accountability at different levels, but the people are the ones who protected the Constitutional Court and other courts are the ones who will have to protect the democracy if they care about their freedom, as I say in the epilogue. The second one is, I've reminded people in certain law schools that the highest form of accountability is elections are the highest form of political accountability. So electoral accountability is the highest form of accountability. It's all that the people have in their hands. And they have to think through this carefully if we are to fulfill some of this. 3, I think to young lawyers, I want to see good, young, bright lawyers coming out of universities, going to Advocate Batoy and saying, I want to be a prosecutor. She says, here's how many posts I had the other day. It's a large number of unoccupied posts. I want to become a researcher for the Hawks. We want the good young people to go there and exercise that public power in a way that will protect all of us. So I want them to rise from the notion that from here, you go straight to practice and make a lot of lolly, to the one that says, no, actually, no. You could become a magistrate and a good one. You could become a prosecutor and a good one. You could become a judge like me. I left all the business I was doing and went on to become a judge. You can be a public servant, in other words. So we're going to have to change our notions about what's important. Some want to be law professors, some want to be researchers. Think about forensic laboratories in our country. Most of the postponements you see in the courts are because the forensic laboratories have nearly collapsed. Try and get a blood sample, Gabriel SC. Try and get an alcohol sample after drunken driving. Try and get tests in a rape case. Or ballistic. If these things are not being done and they're done at forensic laboratories, you're not going to truly, properly fight crime, are you? So you need all these young people to get out of the streets and go and occupy those positions where they re-energize those institutions that we need so badly. And therefore, there's a lot of space. I want young people to go out and go and try and work in land reform areas and demand jobs in those areas so they can help clear a 25-year backlog of land claims. And we who work in the courts know it is so. So there is a lot that can be done, a lot that we have to do. We can't sit on our hands. And yes, All Rise is meant to awaken our young people and society to the fact that ultimately they are their own liberators. And therefore to gut what they have to themselves. And we can debate how good or bad the Constitution is. I would like to have that debate. But in the meantime, can we just honor the essential entitlements that we write out there? Water, food, quality education, health care, access to land, and we can go on down that route. So that is, I hope, what will happen, and therefore there'll be more and more civil society entities, and there are a few already that exist. We need more, even closer to the people, what the people need. Maybe you need more, or you need more of any of those entities where people say what they don't have and they're entitled to have. That's my idea of all of us rising. And of course, I've got stuff for the academy in other ways, but there may not be time to talk about how I think the academy ought to reconfigure some of the things that they are teaching. Thanks.
Thanks. Professor,
Andrea,
can I make a final comment?
Yes,
and that
of course.
I think what comes through very clearly in your book, Justice Moseneke, when you go through the hundreds and hundreds of court cases that the court has put out it's a remarkable number of written judgments that we have, and it is an achievement that we need to be proud of. But what comes through for me very clearly are the two core themes which the court has dealt with, and the one is the basics of human dignity: electricity, water, a roof over your head, land tenure. And then also the basics of office. You know, back from the early days when Parliament was held to account for allowing President Mandela to assume powers he didn't have, to more recently with the stiffened necks of impunity judgments. I think that it's a good collection, a historical collection, and certainly of shows us the value of our legal system and our constitution, which I affectionately call my constipation. Thank you. Thanks again, Justice Moseneke.
Thank you.
Thank you very much, Andrea. Justice Moseneke, we have, I wanted to use the term like millions, but we have a significant number of questions and a very short time within which to try and get through as many as possible. But before I give an opportunity to the questions that have been posed, there is a question that has been something that I wanted to ask you based on a comment you make in your book. You say that the people in South Africa have reposed their trust in the courts. Now, what's of particular concern is that during these dark days, when there are attacks from without and within the judiciary, what would you say your views are about it, and how would you comment on that, especially since this is viewed in the most serious light by the vast majority of the population of this country? Thank you.
Yeah. Yes, Professor Reddy, thank you for that. It's but I'd hope that I would find a way to duck that and escape that. But the fact is that courts have to keep their noses clean, judges more so, more specifically. And therefore it remains and continues to be very important that firstly, enjoy the support of people at large, which we have by and large. Well, that most judges and what they don't have bodyguards, they don't have resources, they work there and they do their work and they do it as well as they can. And yet they have done the work. You open up your television every morning, just see how many magistrates are there, hearing all sorts of cases and contentious bail applications and what else. And proof that they wake up, they go to the courts and they sit there and hear out cases. So we have a reasonable system that is working. And largely because the people support it. Most of the cases that we had, even those who pilloried us and criticized us, came to the courts when they were in conflict. Think of just the many party disputes that we had to decide in the Constitutional Court, because that's where people will end up when they fight even amongst themselves. So yes, the courts have been criticized quite, sometimes fairly, sometimes unfairly, but there's been a lot of political criticism. And I've always said to young judges, you're like a referee sitting in the middle of a match between blue bulls and sharks. but I would cheer for Blue Bulls because I'm from Pretoria. And I would hope the referee would blow all the penalties in favor of Blue Bulls. If the referee doesn't, you know, the referees get pillories, they get sworn at, but good referees keep their head high up. They refuse to be touched by any of the players, and they know the rules, and they call the rules as they should to the end of the match. And that's what judges ought to do, particularly under siege, when they're being criticized. Internally, judges must behave. They can't afford to be seen to be at each other's throats. But above all, I think they should be faithful to the code of ethics. We have a quite good code of ethics, which is globally good. It follows other codes around the world. And we are no exception. And judges must promptly submit to those codes. Because judges know exactly how to run rings procedurally around charges. And we haven't come out smelling like roses, have we? So I still hope that we will take it in and have judges who are more accountable and more like all other arms of the state. Thanks.
Thank you very much for your response, Justice Moseneke. I'd like to now go to a question posed by a master's student in business law, Mr. Mabaso, and he says, I am an LLM business law student, soon to do my articles in Pretoria, the DCJ's hometown. Through my dissertation, I was writing and I noticed that it was as if I was doing English law. There is little to no difference between the two systems of law. The question is, why have the courts not looked into customary law to decide cases where African principles can apply instead of repeating colonial law? Why haven't we seen the injection of Ubuntu as the base of all African jurisprudence? Do scholars have any role to play in pushing that concept to be the norm instead of English principles?
Yeah. Well, at a principial level, our law should reflect the opposite of our colonial past. So we are agreed on that, Mr. Mabaso. And in the book, I take time to show you that the common law has colonial origins and there's a colonial imposition. And that was common to the ruling elite, not common to the people. But it was an incident of conquest, and therefore it was the law that was with us, what, over 300 years. Not out of choice, as I make the point in the book when I tell about my LLB studies. Now, it is not entirely fair to suggest that all interpretation of the law has followed English law without more. I think you will find courts that will never look at the Constitution or any notions of change or look at African indigenous knowledge systems or to look at Ubuntu, but there are courts that do. And the Constitutional Court, I think, is one of those who are right up front there. When we had occasion to examine, for instance, indigenous law and those parts of it that are limited in terms of present-day values. You must know about Bear, you must know about Namitwa and judgments like that, where we said, no, the values must be consistent with the most recent recordal of what we think are good values. I'm familiar with the criticism. I think the Constitution is capable of transformative power if used properly. But I also acknowledge that there are law schools and there are courts and judges who still prefer to use only English law as it is, or company law, or Roman Dutch law as it is. And there is a retreat into a place that we should not go to. So all I can say is that in principle, yes, we should strive to produce a legal system that is inspired by most of the values that we've agreed on in the Constitution. But to say every court, every judge, and everyone has retreated into colonial patterns of reasoning and so on is less than correct, I think. But that debate needs longer time, which we don't have today. So I might be invited one day to the university and we can have a robust discussion about that.
We will be taking you up on that invitation. Thank you. I'd like to move to another question now, please. This is in respect to the Life Isidimeni saga. And the question is, from an emotional perspective, how did the justice navigate through all those highly emotional and charged testimonies? Importantly, has he healed from that commission after giving his remedial actions? Over to you, Judge.
And importantly, I'm sorry, the last part I did not quite pick up.
Importantly, have you healed from the commission after giving your remedial actions?
Yes, of course, most of the psychiatrists and psychologists who gave evidence there thought I should submit to counseling, and that I've been exposed to so much excessive trauma. Of course, like a nice, good township boy who grew up in rough areas and rough terrain, thought, okay, I should be okay, I should be fine. I hope I am. But it's been offered to me a few times to debrief. And I have not debriefed in the formal sense that psychologists and psychiatrists would call for. But certainly I have addressed so many gatherings and talked about it so often that probably I have had a public debriefing. It was tough, it was difficult, it was emotional, you all know. The albums of decomposed bodies, there were a lot of failures and there was a lot of inhumanity. And I wrote about it also. That must have helped in healing. I wrote quite a fulsome award in which I set out what the law is at international and local level, and the breaches that came out of it, and what I thought were the offenses that were committed. But that was not within my remit. So I feel better, and I wrote about it again now in All Rise. So I hope I'm okay.
Thank you, Justice. I have another question from Desiree Erasmus, and she says, are there significant steps in place to ensure that the next Chief Justice is not so-called captured? Would the judge be willing to share who his choice would be and why? Also, I would appreciate the judge's thoughts on the number of seemingly unscrupulous and politically aligned DPPs heading up provinces who simply get shifted around when their ethics and decisions are questioned. How do we get out of this pattern? Thank you.
I don't know how we get out of the pattern. We need honest brokers who have the power to appoint DPPs. We need to revisit the institution because now we know how important it is. And there are architectural limitations in the way we conceived the NPA. There are various models, as you know. In some countries, the Attorney General sits on the cabinet, and there's no pretense that he would act independently. And there are other countries where NDPP is supposed to be indeed an independent broker. You know, in the US, for instance, the Attorney General is anything but independent. We've seen that come through. In places like Kenya, the Attorney General sits on the cabinet. So it's overtly and openly part of the political machinery. In the other countries where the national director is meant to be, supposed to be, and you've seen some moves to say it must be converted into a Chapter 9 institution. So we need some structural reform there, not just people, but also to whom do they account and in what way. And Glenister was in part about that, about possible political overreach on people who have to exercise very delicate and drastic powers. So that's my answer to that. And I think I'm going to leave it at that point. When we get new judges, I hope that we will there's a role for civil society, which has not been played sufficiently. You can make submissions to the JSC. You can write and say what you think and feel about Judge X, Y, or Z, who wants to become Chief Justice, who wants to become what. So we're going to need more active citizenry and people saying they care who their Chief Justice is. They care who their Justices of the Constitutional Court are. But my last point is that it's difficult to capture a judge, almost impossible. If you capture one judge and we are 11 at the Constitutional Court, you're not going to move the needle. When the SCA, you get 1 or 2, and there are 5 judges, not going to move the needle. The High Court, there are 3 judges, you won't move the needle. So you're going to have to find a big conspiracy to capture the judiciary, the way it is currently structured. Maybe 1 judge sitting alone, but all that is subject to appeal anyway.
Thank you very much, Justice Moseneke. In the interest of time, I'm going to ask one final question from the audience and then ask our 2 panelists if they have anything that they would like to raise with you further. So the question from our audience is from Professor Vauder, who says, one of the stark realities of the COVID-19 pandemic has been the shortage of health products. It is widely accepted that this is due to strong intellectual property rights protection, leaving the manufacture and distribution of essential products in the hands of a few pharmaceutical companies. This problem has been long recognized by our government, resulting in a new intellectual property policy in 2018 based on public health considerations. It is therefore a great concern that the Constitutional Court has apparently shown a reluctance to engage with important intellectual property related issues. For example, the decision in the Cipla MedPro versus Adventis Pharma matter, or when presented with the opportunity, delivered an evenly split decision, resulting in the judgment of the SCA to stand. What are your views on the issue? Is one of the reasons for this an apparent lack of expertise in this field? And given that intellectual property disputes routinely raise constitutional issues, what are the implications of this situation for a truly transformative jurisprudence? Thank you.
Yes, I mean, it's one of the issues that indeed should attention. If you remember quite the early days with all the series of pharmaceutical judgments, the battle was already right up there. And even TAC originally, as some commentators have shown, really arose from intellectual property rights of manufacturers and the pricing issue and whether or not we will ever afford this if we still keep to the same intellectual property arrangements. Comes new policy and then interpretations. I'm very loath to second guess judgments of my colleagues for obvious and very good reason, having not so long come off the bench. And in the book, I've been quite careful not to try and second guess the judgments and say they should have been this and not that. It's generally not done, and you leave it to the academy to do that. And there should be enough firepower to be able to raise that. As a generic question, intellectual property rights sit in the heart of the kind of transformation we need in this country and indeed in many countries in the global south. And it's a very important topic, and I hope the courts will not shy away from it and they'll actually tackle this, but so too the academy. It's important to highlight this. And that's where activism, both academic and civil activism, comes to the fore. Thanks.
Thank you, Justice. I'm now going to ask Andrea, do you have any final words or any final questions you'd like to pose to Justice Moseneke?
Yes, well, just to really urge all of those that are listening, and I've had the privilege of being a part of this webinar, to read the book. It's an important historical book, and in a way, it contains, I think, the seeds for a new manifesto. It's that good. So thank you very much, Justice Moseneke. And it just occurs to me from listening to the participants and to the questions, I think it really is time that we reminded those in public office that they do work for us and that they are subject to the Constitution, and that public office is really public servantship to all of us. And those are my parting thoughts. Thank you again, Justice Moseneke.
Thank you, Andrea.
Thanks very much, Andrea. Warren, do you have any final comments or questions to pose? Thank you.
Thanks, Manny. I'll just also comment because I'll just make a comment because I see we're running out of time. So I just wanted to echo Andrea's words. I think it's an absolutely fabulous book, and I urge everyone to read it. It was an easy read, and what I also particularly liked is it had a number of wonderful, wonderful photos in it. Certainly the edition that I did. Yeah, so students, practitioners, general public, really, it's well worth reading. And thanks again, Justice Moseneke. I think it really makes a contribution to, well, legal literature, but to literature in general in South Africa.
Thanks very much, Warren. And finally, Justice Moseneke, do you have any final words before I issue my vote of thanks?
No, only to say ngiyabonga. I am most grateful. And I think the law school, starting with you, Dean, and everybody who has been involved in this. Hazel has been on my case all the time, checking whether I'll arrive and make it. I easily got 10 reminders, which was excellent, urging on to action. And it was a privilege to be here. I truly hope it's really not about, buying books and things. And that is why I've donated books for those who want to read them. They'll find them in your library and they should read from there. It is truly about kickstarting a fresh discussion about where we are and where we hope to go. So that is what it is. And it has been, as you all know, wonderful to go around law schools and to hear, and there are other issues which require more debate, and it's not possible to do them in a setting like this. But we need to debate those issues, particularly with younger people who are very uncomfortable about where we are and whether the discomfort comes from the Constitution or the power elite. It's a debate I hope to have. But again, ngiyabonga.
Thank you very much, Justice Moseneke, for those final comments. Ladies and gentlemen, we've had the opportunity this afternoon to have a gentle peregrination through a fascinating book. And as you've heard from the panelists, this is a book that you'll be well advised to read. Importantly, we've also had the opportunity to tap into the wisdom of this brilliant jurist, Justice Moseneke. And the one parting bit of advice that he's given us, which I hope will resonate with all and that we will try and do something about, is to become active citizenry. So may I issue that welcome to you all to join the call to become active citizens and to all rise in process. This afternoon has been really pleasant, but it would not have been possible had it not been for the support and assistance of a few people that I'd like to now mention and acknowledge, beginning with Pan Macmillan and their organizing team, who worked very closely with Ms. Hazel Langa, who is our public relations manager at the University of KwaZulu-Natal. So thank you to Pan Macmillan and the team for organizing this event. And I'd also like to thank, in the warmest of terms, our two panelists who've done such a brilliant job of indicating what it is that they found fascinating about this enthralling book. And they are Ms. Andrea Gabriel and Professor Warren Friedman. You've also raised cutting issues that we've had brilliant responses to from Justice Moseneke, so thank you for doing that. And then my PA, Carol Nasia, has been right arm to Hazel Langa. I'd like to acknowledge her and thank her as well. And ladies and gentlemen, I'd like to express a special thanks to Justice Moseneke for his time this afternoon, but more especially for the generosity he displayed, not just to my law school, but to all 16 law schools and law faculties in our country by making a very generous donation of books to each of us. To our school, he's donated 30 copies of All Rise, and these are going to be located in 5 libraries throughout our 5 campuses. And the book, as you know, has been written in terms that anybody would be able to grasp and understand. So we're not only placing these books in the law libraries, but also in the libraries where students in other disciplines will be able to access that. But thank you so much, Justice Moseneke, for that wonderful act of generosity. We will not forget that. And finally, ladies and gentlemen, I'd like to thank you very much for your participation. We really appreciate the questions that you've put through, but I must apologize that we haven't been able to go through all the questions. I'm sure Justice Moseneke would invite any contact from you by email or in whatever way you would seek if you have issues that you would like responses to. But thank you very much for your participation and for the very complimentary comments you've made about Justice Moseneke's book as well as our panelists. Thank you, everybody, and goodbye.